welcome to Crime in Court. My name is Heather, and this is a rewatch of the hearing that took place yesterday, so Thursday, May 2nd, in the afternoon. So I am rewatching this in the morning of May 3rd. I'm going to get it out to you guys as soon as I'm done, get it scheduled for the day, and let's not delay. Let's get ready. So please hit that like button before we dive in, and I appreciate you guys just for being here. Thank you so much. All right, so we are here in a hearing for the Idaho versus Brian Kohberger, and as the thumbnail stated, the state wants to close hearings to the public, so they have an upcoming hearing. I think it's scheduled for 2 or 3 days to talk about motion to compel discovery regarding the IGG information, and the state has filed a motion to make the hearing closed to the public. And the defendant very much objects, and we're going to hear some fireworks today and some bombshells and all sorts of good things. So let's begin.
I have a few things just to sort out today. The first thing I want to talk about is whether or not this hearing should be sealed. What's your position, Ms. Taylor?
Your Honor, this hearing should not be sealed.
Okay. Mr. Thompson? Ms. Jennings?
Your Honor, the state's prepared to do its argument today without actually talking about the specific request that we're trying to protect within the discovery request. And so as long as those specifics are not discussed or mentioned, then I think we can go forward with an open hearing today.
Okay. Are you comfortable with that, Ms. Taylor?
Well, what I'm not going to talk about is the content of the court's protected materials that we've asked for a sealed hearing for. What I'm prepared to talk about is why should we seal this particular motion to compel that's set to be heard, and how much else is in the public record, and why there's no compelling reason to seal that, and why that violates Mr. Kohberger's constitutional rights. So if I talk about things that are in the affidavit, and if I talk about things that we're seeking that the state wants to hide, I think that's fair game for the public to hear.
It's the challenge here is that both sides have agreed to seal all the discovery. There's a lot of stuff out there, and so I hope that you can both honor that at this point, because down the line, maybe some things do have to discuss. We need to discuss very specifically that maybe both sides don't want that out in the public, because it is a fair trial goal here, and if we start arguing about the case itself, the trial, and the evidence that you're gonna present, both sides, it's more complicated and may be prejudicial to one or the other. So I guess at this point we'll keep this open, but be careful. I mean, I've read everything, so I know what's sort of out there and what you're concerned about, and some of those materials or potential evidence could be prejudicial to the state, or it could be prejudicial to Mr. Kohberger. So my job is to try to keep on a balance here, a neutral balance, where when we get to the trial, if we ever get there, that it'll be fair and will have been determined in advance. Okay, so keep it open today. If something comes up and we need to close it down for a period of time to discuss a particular situation, then we can do that. Okay, so it really...
So the state came ready to say, hey, we can keep it open. We're okay with that. So,
I think at this point, it's the state's motion to close the hearing completely on May 14th. I believe, I'm not incorrect, that you both have stipulated to closing May 16th, which is related to the IGG.
Your Honor, our position is that's the only part that should be closed, and that's because we want to talk about the content of the materials protected by the court's order, and so that one's appropriate to close.
Okay.
So the defense agrees, let's close a hearing on the 16th because that's regarding protected order material regarding the IGG information. However, it's like I said, it's like a 2 or 3 day hearing where not all of it should be closed to the public.
Okay, I think I'm on the same page, but great. Okay, Ms. Jennings.
Thank you, Judge. So, Judge, the applicable authority today in determining whether or not we should close the May 14th hearing is Idaho Administrative Court Rule 32 and Idaho Code 74-124. Both contemplate balancing this public right to an open hearing versus the interests such as privacy, safety, and the right to a public trial or to a fair trial. In deciding whether or not to file the
This is the state. Ms. Jennings is arguing for the state here. You can see Bill Thompson is sitting down right there. There's Ann Taylor. There's Brian Koberger. There's a bailiff. And then there's the judge. Just so you are clear on who everybody is who's speaking. It's very hard to see because the people are so tiny. But it is what we have. So
motion to close the hearing, the state weighed those interests and ultimately came down that the need to protect the privacy and the sensitive information and ultimately protect the state and defendant's right to a fair trial outweighs the right to an open hearing. Feel confident that when the court does the same balancing test, it'll come to the same conclusion. For the record, since the beginning of this case, attachments detailing the specific discovery request have been filed under seal. In line with this, on April 4th of 2024, just about a month ago, the state and defense filed a stipulated motion to file all future attachments under seal. Today, we're specifically discussing the defendant's fourth and fifth motion to compel discovery. Concurrent with the defendant's fourth motion to compel discovery, the defendant motioned the court that the details be filed under seal, citing Rule 32. Concurrent with the fifth motion to compel discovery, both parties stipulated to filing the details under seal, citing Rule 32 as well as Idaho Code 74-124. So the state followed course. We have filed all of our responses under seal and then filed this motion to close the hearing to discuss those previously sealed details. Now the defense is taking a contradictory position and asking the court to ignore all the previous filings, and this is just entirely inconsistent. To be clear, the state has nothing to hide. However, it's crucial that we protect, as we have been trying, the integrity of this case, and that we protect, ultimately, the right to a fair trial.
it's interesting because there's been a lot of criticism about the state and what are they hiding because they don't turn over discovery. And Ann's on a 14th motion to compel certain discovery, and this is a different issue related discovery. So this is just the fourth time asking for whatever. So the fourth and fifth motions for this whatever discovery. But it's ridiculous. Like, they shouldn't have to ask you 14 times for discovery. Yet they're like, we have nothing to hide. Okay.
So let's look at the factors. Balancing a public's right to an open hearing and the party's right to a fair trial. Let's go to the factors laid out by Rule 32 and Idaho Code 74-124. And when we do that, for defense's fourth motion to compel, Item 1, Subpart A, discusses federal grand jury materials. Those are exempt from disclosure by federal law, as well as Idaho Code 74-104, subsection 2. What they specify as subparts B through N, all of those items discuss evidence related to this investigation, of which disclosure would, 1, interfere with enforcement proceedings pursuant to 74-124, subsection A, deprive the defendant a right to a fair trial and the state, subject to 74-124, subsection B, and Rule 32, subsection E. And it would disclose investigative techniques or procedures which are exempt pursuant to 74.
It would disclose the investigative techniques or procedures that were not followed and blatantly disregarded. And don't you think we should know that?
124, subsection E. For defense's fifth motion to compel, item 1, subparts A through J, all deal with the investigation. All would be exempt pursuant to the same authority just cited. Subparts K through M deal with the names of private citizens who were interviewed, and disclosure would constitute an unwarranted invasion of personal privacy, subject to 74-104 subsection C. It could contain intimate facts or statements of which would be highly objectionable to a reasonable person, exempt under Rule 32 I-2A, or invoke traditional legal concepts in the law of the right to a fair trial, invasion of privacy, under Rule 32 subsection 3. Subpart N through O is exempt under interfering with enforcement proceeding, depriving the defendant to a fair trial, as well as disclosing investigative techniques or procedures. Item 2, subpart A, names a private business and is exempt under the previously cited authority. Item 2, subpart B through L, deals with the investigation, again exempt under 74-124A, subsection B and E, as well as Rule 32, subsection E. Item 3 names multiple private businesses. It's also exempt under the same subsection, 74-124A, B, E, C, as well as Rule 32-12A and 3. Subpart I deals with the investigation, exempt under those same authorities. Subpart J involves a private citizen, exempt under those same authorities. Subpart K through B deals with the investigation and is exempt under those same authorities. Item 4 deals with IGG information, which has been sealed and is under a protective order from the court protecting its disclosure. If the court decides to open this hearing to the public, the state defense will be discussing evidence without any context. This will undoubtedly fuel speculation, lead to assumptions and false narratives. The evidence discussed may not even...
Assumptions and false narratives are already out there because you're hiding everything. Because everything's being filed under seal. Everyone has to make up their own speculation and come up with their own theories because we're not getting enough information from the prosecution, from law enforcement, from anybody over there. So, yeah, the narrative is so tightly sealed that, you know, people make up their own narratives. And it's unfortunate.
Even be offered, and most of it likely will not be offered by either party at trial because it's either not relevant or material. The public will not have any means or context to be able to differentiate that. It is necessary to mitigate this by closing the hearing in order to preserve the right to a fair trial for both parties. The defendant does have a right to a public trial, but that does not mean the right to try this case in the media. The defendant will get his day in court, and the public will have a right to see what evidence the state has. But that should be evidence that is admissible pursuant to the Idaho Rules of Evidence. Now is not the time for that. We ask the court to grant the state's motion to close the hearing regarding the defendant's fourth and fifth motion to compel discovery. Lastly, I ask you to issue a scheduling order for the parties to disclose witnesses, exhibits, expert reports, or any other evidence they plan on relying on for those hearings. Prior to the hearing, the state proposed May 3rd, and then a response to those by May 10th. And the state takes no issue with this being a dual deadline. Thank you.
Yeah, thank you. May 3rd might be a little quick.
Well, Your Honor,
Tomorrow?
right, but our motion was filed over a week ago.
Right.
So everyone's been on notice of what the state was asking for.
Okay, thank you. Thank you, Ms. Taylor. Ms. Taylor?
Thank you, Judge. Our discovery requests have been filed for months, and they've gone unanswered too. So if we want to talk about being on notice for something, we can talk about that.
Can I just add, because I've read through all of the fourth and fifth, and it's, I mean, some of the information, it seems anyway, I mean, I'm not, it's hard to know, okay, but it seems like the state has provided and has responded to some of those requests, and some they're still waiting to get that information. So that's the impression I had. I don't know if you disagree with that or not.
I would say the court is maybe in part right, but there's a lot of other parts to those fourth and fifth, and the court's referring to our motions to compel, not discovery requests themselves, but they do reference a number of discovery requests that have been going out. And we can talk specifically about each of those items.
I prefer not to.
And which is fine. I'm prepared to talk about why this needs to not be a closed proceeding today. But I don't agree that the state is completely responsive here. So I think the court can read and see that they say, we'll get it when you get it. I think the court can read and see when they say, we're not going to offer it, so we're not going to get it. I think the court can read all of those things. And we'll talk in depth on the 14th about what they mean and some of the ins and outs that go into play with those. But there's a lot more than just meets the eye. With regard to the hearing on the 14th, the state directs the court to look at Idaho Court Administrative Rule 32 and Idaho Code Title 74. And those really talk about documents that the court can seal. And both really are in, if you look at them, they are to talk about openness of the court and public's right to have information and what things the court can shield from the public and what the public has a right to know. And when we're talking about documents, it's been brought up that we've filed a lot of documents under seal. We have. Those are documents that end up in the public record that thousands of people can read. And we file those under seal for expediency and saying, this is exactly what we want from discovery. If the court looks at the documents, and the court can, and probably has through the year and a half this case has been pending, there are a lot of names and specific bits of information in there. And so for expediency, we file those under seal and for the reasons outlined in Idaho Court Administrative Rule 32. But what we're talking about now is a public hearing when the state has decided to not give us information or to drag their feet on giving us information. We're talking about a public hearing where we have a right to be in the public eye, a public hearing. Brian's the one with the right. It's his Sixth Amendment right to have a public hearing. When the state wants to close a hearing, or any party, and the other party objects, which we do, the court is guided by case law in the state of Idaho and the backdrop of his Sixth Amendment right to a public trial in the United States Constitution and Article 1, Section 13 in the Idaho Constitution. So in the backdrop of that, the court is guided by case law. And the specific case, there's a couple of Idaho cases.
Why can't we argue that in the Delphi case in transparency and wanting a public trial? Because Judge Gull won't allow any cameras or media at all. I mean, I take that back. I believe she allows some media presence in the courtroom, but they can't be using any kind of streaming device or any kind of electronics. You can't even have your cell phone. So Richard Allen has a right to a fair public trial. So does Brian Koberger. These things shouldn't be in the dark. That is why things are supposed to be public, so that the public can see with our own eyes what's going on and the government can't take control. I mean, at least that's the purpose as to why it's supposed to be transparent. But for the most part, there isn't a whole lot of transparency and the government still has all the control. So we really haven't evolved a whole lot since we immigrated here. No, I guess we evolved some. Just kidding.
State versus Kimbley and State versus Olivine, and they refer the court to Waller versus Georgia, and that is at 467 U.S. 39. And that puts forth the test that the court should look at when determining whether to close a hearing or leave it open and let it be a public hearing. And that the court has to find that there's an overriding interest that the hearing should be closed. In this case, in this hearing, that's not what's happening. The court would look at Brian's rights here to a fair trial and balance that against the state's request to close the hearing. And we would want the court to consider that this isn't the state trying to protect Brian's interests at all. He has the right to the public hearing. This is the state trying to protect what the state's doing. And the court should look back through the history of this case. This is our fourth and fifth motion to compel. Motions to compel 1, 2, and 3 were public. They were right out in the open with the public. The specific discovery requests were also sealed. So this has been a pattern to do things in the public. And now this one needs to be sealed. The court has to ask itself why. And the court should ask itself, what is the state trying to hide here? The things that we're seeking in these motions to compel are things that are outlined in the probable cause affidavit affidavit that has been public for a year and a half now, that has been offered to be shared far and wide. We're looking for things like videos that the state said they collected so that we don't look at things in a little vacuum. The state tells you not to take it out of context, but that's what they're doing when they want us to do this in private and not let the state know about the full scope of the videos that are out there that they haven't given us. That is the state.
It's so corrupt and so dirty, so underhanded. A lot of prosecutors play this game with discovery, and it makes me sick. How are you supposed to defend your client if the state has all the power and all the discovery? The law, we need to change how we do things, like completely. Discovery, okay, law enforcement shouldn't be in the pockets of the prosecutor and vice versa. It should be, okay, law enforcement has discovery, hand it over to both sides all at once. It shouldn't be this prosecution keeps a hold of it, just like in the Delphi case where they were kicked, the first attorneys were kicked off the case. They had all their discovery organized the way they wanted it, and then Judge Gull takes it all back, says give it to McLeland. McLeland goes and changes everything again. So it's now going to be a totally different type of discovery than what they had before because they added things that weren't there before and slipped things in secretly and surreptitiously trying to get here's the exculpatory information, but it's labeled something else, so they play these games and it is so disgusting. It makes me furious inside. I don't know what the answer is other than share discovery from law enforcement. Stop feeding each other hand in hand, prosecution and law enforcement. It's got to stop. It's got to stop. Michael Morrissey, the DA in Canton. Sorry. Here we go.
Keeping things in a vacuum to control the public narrative. And that violates Mr. Koberger's rights. That's what we want to prevent. This needs to be out in the open. Your Honor, I'll give you a couple of examples. The state filed last June its motion for protective order of the IGG materials. That motion was filed in public. It's on the public record. People can print that and read that and do all day long. And that had information that was negative about Mr. Koberger in it. So that's out there in the public. But that order was to protect information, the IGG information, that they say details how the state got to Brian in the first place. That's been sealed. That's fine. We respect that. But you have to question, why can we not talk about the things they're not giving us? Why can we not talk about the cell phone information, the tower information, the drive test information in a public arena? Why should Brian have to have his case when he's asking for this information be done in a little vacuum where the state says what the public can hear and what the public can't hear?
Damn straight, Ann Taylor. Damn straight. Love it. I love a powerful argument by a lawyer. It just gets me fired up. I could never do what they do, but I mean, I don't know. It's so great when you have a really engaged attorney like Ann Taylor or the attorneys in Delphi or in the Karen Reed case, and they are just dedicated. And I mean, that's what they're supposed to do, zealously represent their client. But I also believe that they believe their clients are innocent. And there's a lot of evidence to back that up.
Another example of this, Your Honor, is with the video tape that they've relied a lot on in their probable cause affidavit that we've received different parts of. Part of the hearing on the 14th is to talk about the different parts of that video that we've received and how we need the whole context. This is the video that they...
So they're only giving them portions of a video that they're using to say this proves Brian's the culprit, but yet you can't have the entire video to view to defend your client. Crazy. This is crazy.
Different parts of
it.
Part of the hearing on the 14th is to talk about the different parts of that video that we've received and how we need the whole context. This is the video that they say places this car near the residence. We've received little tiny pieces of that. And we think Brian's right to a fair trial means the public needs to know that they've withheld the audio from a great portion of that and that it starts a long time before the little clip that we've received.
Hell yeah. Sorry, I don't mean to interrupt her, but hell yeah. the audience or the public does need to know that they've been withholding the audio of these video clips. I'm gonna skip back because I was talking, so sorry. I'll let her go on her thing. She's just getting me fired up. I'm behind her 100%. She sounds awesome.
We think Brian's right to a fair trial means the public needs to know that they withheld the audio from a great portion of that, and that it starts a long time before the little clip that we've received.
Yep.
To do this in a vacuum, Judge, when documents are filed under seal, that's fine. Those are documents. But this hearing needs to be in the public eye. For the court to allow the prosecutor to say, we need to keep this all private for a fair trial, really ignores the public nature of this case. It really ignores the fact that Brian has been essentially convicted in the media. You don't have to read but a few articles to see how negative they are about him. He has a right to have this information withheld, brought out in public, so that people can see it's not this neat little package. So people can start to wonder if Brian's innocent. Your Honor, Brian is innocent. And he has an absolute Sixth Amendment right to have his hearings in public. We think if the court allows the state to shield the information and how they got their information and what they don't want us to have from the public, they're using his Sixth Amendment rights to hide behind. And that's just not what the court should allow. We strongly object to these kinds of things being closed.
Thank you, Ms. Taylor. You know, I don't know where did it stop though. I mean, if we start pulling out all the potential evidence for the trial before the trial, then does the state get to respond to that? And that's where does it start? I mean, it or stop. It just is a roll of that. And so either side, okay, that it sends to the public that it is not, you don't get the context. They don't have the context, the public. You have the context. You want more context. I get that. But it's really difficult to say, to just open that up and talk about particular issues in the case without talking about the entirety of the case. And that's what trials are for. I mean, I totally understand that Mr. Koberger has a constitutional right to a public trial, but having a hearing is not a trial. That's something different. And so that's why, that's where the balance.
But isn't it part of the proceedings, part of the ways in which the prosecution can prejudice everyone against the defendant? If you're not, yeah, I mean, he should have a right to them being public. It's part of the proceedings to his trial. And these motions, I've heard so many lawyers talk about these pre-trial hearings are so important because the years leading up to the trial is where you do a lot of your negotiation as to what actually comes in or stays out of the trial. So it's a lot of, it's fighting back and forth, but these are so important because you can really shape the trajectory of a trial by what comes in and what stays out regarding certain evidence, and you can put in your motions in limine and keep things from coming in that might ultimately, be exculpatory or whatever, but it comes down to these hearings and how they're argued and what the judge decides. Some judges, like Judge Gull in Delphi and Judge Cannoni in the Karen Reed case, are showing their bias completely through and through. This guy, at least Judge, has been very even keel, and for the most part, I think he's really trying to balance and make a fair trial happen. But a lot of judges still tend to lead to the state side, which I do see a little bit in his rulings as well, but he far and away much more even-handed than a lot of the lawyers that I've seen in the cases I'm doing now. So, but you never know what's going on underneath the surface. So he could be very fair up front, and maybe during trial he could change his tune. I don't know. But this is just observations I'm making and speculation on my part. So far, Judge, I like him. But I don't like Bill Thompson and the underhanded ways that the state is hiding stuff. And I am very, very impressed with Ann Taylor and a lot of her arguments. So let's continue.
Balancing comes to, if you want to answer it.
I do, Judge. The Waller versus Georgia case is in the context of a motion to suppress. If the court starts closing hearings now, when the court hasn't closed the other motions to compel, what's the court going to do when it comes time for a motion to suppress? Those are coming. Many of them are coming. We want the hearings in public. The state has dropped bits of information with different filings they've made all throughout the way.
And most prosecution offices do this. And this is how the rumors start and news takes off with a document that they get, and they take one little piece like stargazing and run with it. I imagine there might be some stargazing talk involved in this hearing too.
This can't be done in private. It just can't.
I'd say both sides have said in their motions or their briefs that they disclosed, certain things, and it's a change. See that because both sides have agreed to seal a lot of these issues of evidence in the discovery, and so all of a sudden it just does feel like it's moving in a different direction. But I understand what you said. It's like this isn't about the discovery. This is about the hearing.
Your Honor, those are discovery documents, and there are things in there that the state's chosen to respond to. The state selected which things that we have to have a hearing about, and these are about things that are in the state's possession or control that we want them to give us, and we're asking you to order them to give us these items so that we can do our work, so we can complete our investigation.
The judge knows this, but Anne's telling us for the public. I think she's telling us what she's trying to accomplish by doing this. And she's not only just addressing the judge, I think she's addressing the public as well, stating like, hey, my client is not getting a fair trial in the media right now. I'm really trying to make it more fair for him. So I really think that she's speaking to all of us as well.
It's not any different at all. Sealing the documents, I think that needs to continue to happen. That there are a lot of names in those documents and requests for follow-up. We don't have to do that. I do think those are fine, and I think they're different because they're documents that are going to sit in the public record they're different than having a hearing of things that the parties haven't been able to resolve on their own that the court needs to resolve. Public has a right to see how its business is carried out. My interest is Brian's right. But I would ask the court to remember the history. We've had motions to compel 1, 2, and 3 from the public eye. All of a sudden we get to 4 and 5, and we understand the subpart of 5 that has to be in a sealed proceeding. That is going to directly deal with documents the court has ordered to be protected. That's completely different than when the state won't give us bits of information that's within their possession and control that we need to prepare our case. Your Honor, I would ask the court to consider, too, how much pressure there is to get to trial. We've heard the state say they'd be ready by this summer. We've heard the state say they're going to be ready by March of 2025. We've heard them say that they've given us 95% of discovery. We've heard them say they've given us all of the discovery, and those things just aren't true. They're just not true. You can see from the list of things we don't have, there's no way we have 95% of it. So when there's all of that in the public eye and the pressure of let's get to trial, I think
basically she said, Judge, he's lied to you about turning everything over. He's told you that he's given us everything, or that he's given us 95% of things, and I can unequivocally tell you that is not true. And if you look at the list of discovery that I still need, you would think so too. So he's lied to you. Bill Thompson is a liar.
the public has a right to see, and Brian has a right for the public to see that we're trying the best that we can. The court offered to do what it could to speed this up. Having hearings about things that shouldn't be closed, that we object to being closed, takes time. There is no change in our habit or our practice filing documents under seal for things that meet Idaho Court Administrative Rule 32, subsection I, and us asking for a public hearing. There's nothing inconsistent about that, and that's the way we've carried out the case.
Thank you, Ms. Taylor. Response, Ms. Jennings?
Yes, Your Honor. Taylor's argument and multiple completely false narratives are the exact reason
why this hearing should be closed.
Wait, what? So Ann Taylor's just lying about everything as she calls you out for not handing stuff over? Okay.
Yes, defense has a right to a public trial, but that is not the right to having all hearings open to the public. The court's right. There will be a day for this, and that is the trial. But we shouldn't be discussing all the evidence that we're going to hear at trial prior to that. There's no right to try this case in the media. The case law that the defense relies upon has not.
I wonder why this woman is speaking. I don't know her name. It's he called her Jennings, something Jennings. But Bill Thompson, for the last two, has really kind of sat down. So that's kind of intriguing, don't you think? He's letting this woman do the arguing instead of him. I wonder if it's because he knows his case is screwed. I don't know. So he's like, I'll let you lead this one. You take this one, I'll get the next one.
Extended this balancing test to these types of hearings. The hearings are about, or the cases are about trial. And yes, they extended it to a suppression hearing, which was so interrelated to the trial. Waller v. Georgia primarily stands for the proposition that any closure gives you this balancing test. We just went through the balancing test, and the state gave you the reasons for why this meets the test for closing the hearing. As far as being inconsistent, I would just note for the record, we have had one hearing regarding motions to compel. However, at that hearing, this is your order. At the outset of the hearing, the parties informed the court they had reached agreements on all issues except request 160. We discussed one request, and it had to do with training records. That is not what we're contemplating discussing at this hearing on the 14th. I've gone through the multiple issues and subparts, as well as the reasons why we cannot have this discussion in an open forum.
Thank you. Want to respond to any on that, Ms. Taylor?
Well, Your Honor, we had the entire IGG state's motion for protective order and our objection to that in a public forum as well. That ends up resulting in us receiving documents that the court had a protective order on, and we can't even share with our investigators that come to court with us. And we've abided by that, and we understand that.
That's so stupid. It's so stupid. They have investigators working on this case trying to also get to the bottom of the truth or whatever, to look at the evidence, the discovery. And unfortunately, they can't even share the information that they have with the experts that they've hired on to refute the evidence or, to refute and defend Brian. They can't do that because, or not at least without without permission from the judge. Because the state is being little babies about discovery. I don't know why.
The entire hearing leading up to that was done in the public eye. In that particular hearing, they talked a lot about DNA results on a knife sheet. That, I'm sure, benefited the state to have that in the public eye.
Hell yeah.
What we're going to talk about on the 14th, Judge, I don't have to name any private citizen names. I can talk about records that exist and why we should have them without naming private citizen names. I can talk about the videos that they've not given us. They're not about the business. They're about videos that were collected by the police. I can talk about those in the context of the police reports. And by the way, those are all things that are talked about in the probable cause affidavit. And I can talk a ton about the cell phone information, the cell tower information, and the things that they have not given us, the drive test information, the verification of such.
That's the thing. I don't want to talk about those particularly, and I guess I'm reminded.
The verification of what? And she just cut him off. So the state cut her off. Like, don't let her talk about these things. And yeah, so I'm going back a couple seconds so we can listen to that again.
Tower information and the things that they have not given us, the drive test information, the verification of such.
That's the thing. I don't want to talk about those particularly, and I guess I'm reminded, okay, in your comment about the IDG, because once again, I'm in this position where I have to make decisions blindly to some degree, and that's what the case with the IPG. I mean, I had to go through all of that information, and then I provided most of the information to you, okay, to the defense, so that you could evaluate that.
Most of. So what didn't he provide, I wonder?
I feel that the same way about I mean, there's a lot of stuff, okay, that you're arguing about, and the state is arguing about. And I think it's complicated to just open that up. I think that, maybe we could go through a closed hearing and then open up what you feel needs to be opened up. But I can't make that decision in the abstract. So that's my worry, because I went through all this last night again, and I thought, how do we really fairly deal with each one of those issues? There are a lot of issues.
Mhm.
I agree with you. There are a lot of issues, Joe. I would ask you to look at the probable cause affidavit and read the parts where they talk about relying on FBI agents in the cast report and different cell tower data. Your Honor, that stuff's in the public eye. Why can't I talk about what they refuse to give me in the public eye?
Well, one of the things that we want to talk about today is I just got motions for subpoenas, duces take them to the FBI. I mean, it's really difficult to get information from the FBI. You know that. They know that. I know that. We have we have to jump through a bunch of hoops to get particular information from the FBI. That is not the state's issue, although maybe it should have happened 6 months ago.
That's the state's issue.
I understand that. But that is one of the things that, I mean, we can maybe address that today, too. I don't think, thinking that you don't have an objection for me to sign the subpoenas.
No, Your Honor, I don't have an objection for the court to sign the subpoenas to try to get the information.
So I can sign that. I can sign that today.
You can sign that. You can sign that. Anything you need to sign to get us the things we want, please sign.
I'm with you. I'm trying to do that, and from what I've seen, I mean, I think the state is trying to do that. I know that it's not satisfactory from your position, but there's a lot of issues in this case.
And Your Honor, that's really a lot of what we're going to talk about on the 14th, is the timing of these things,
right.
Not the full content of what we think these things might show. We don't know. We don't have them. They know.
Likewise.
So I think the timing is important. Your Honor knows how much pressure there is to get this case to trial, and Your Honor also is aware of all the things that we have to do. And when we make a request and months later you're asked to sign the order so that maybe we can finally get that information, that timing part is important for the public to know. That's not the content. I'm not going to talk about the content of that subpoena you just brought up. I don't need to talk about that at all. But I can talk about the delay in this and why there's a delay in us being ready for trial.
Exactly. If there's misconduct on the prosecution's part, she should absolutely be able to bring that stuff up. If he's deliberately keeping things from the defense, or not turning things over, or turning things over with missing parts, that he's willfully keeping from her, then that's a huge problem. And she has every right to poke holes in that. Every right.
Is fair game for the public, and that is something Brian has an interest in having public. So I don't have to talk about that content. That's not the issue at all. But the things that are laid out in the probable cause affidavit that has been on the court's public website for 1.5 years now, it makes no sense that I can't ask for those things in the public when they're things that the state said they relied on. That just makes no sense. I have one more ask when we're done with this issue.
Okay, thank you. I mean, are you expecting me to make the decision right now? Maybe not.
Well, Judge, you should just make the decision to have the hearing open. And if I start to talk about content, then maybe you can talk about it then. I don't agree any part of it should be closed. I don't agree any part of the hearing should be closed. And I think you should make the decision now. We're 2 weeks away from this hearing.
Oh, 2 weeks? Is that right? 4 days?
We're less than 2 weeks. We're 12 days.
All right. Well, I kind of mentioned this a moment ago. I just feel like we need to get into the details, okay, of all these issues before I open it up. So I'm going to close that hearing. Now, that doesn't mean that after we sort out all of those issues and I have more understanding of why you are getting what you want or what you asked for, or whether or not there is something that you've asked for that doesn't exist, or that some of the materials are holding with the FBI, and that we need to get that. I mean, those are all really complicated processes, and I would feel much more comfortable when, again, I'm trying to protect a fair public trial and not have a maybe not intentional unfair hearing, okay, that goes out to the public. I think that's the balance for me. That I want to see what all the issues are, the arguments from both sides, so that I can make a more informed decision. So I'm going to close the hearing. At some point in that hearing, maybe we can open up part of it. But I need to dig in, and you all need to dig into exactly what is the problem with each one of these issues. All right. So let's talk about the schedule. Okay, the state asked for this, some disclosures of witnesses, expert witnesses, exhibits by May 3rd. I don't think that's particularly practical at this moment. I know that you had, I'm not looking at it right now, you got another idea about that, Ms. Taylor?
Judge, I think I had May 7th.
Okay. That seems more practical. Okay, so I will put an order out, schedule order for.
What did she say? Something that he said seems more practical. Let me rewind. Sorry, missed that.
You got another idea about that, Ms. Taylor?
Judge, I think I had May 7th.
Okay. That seems more practical. Okay, so
deadline.
I will put an order out, schedule order for providing. I don't know if the state really knows what you do until you see what they have. And you're shaking your head, yes.
Yes, sir.
And that means that maybe you don't have any witnesses, expert reports, or exhibits at this point because you don't know what to expect. And this is related to the hearing on the 16th,
I
right?
think the 14th, I'm not sure.
Okay. And there may be witnesses on the 14th too, as well?
Yes, Your Honor.
Okay. All right, so let's make it May 7th for disclosing witnesses, expert reports, and exhibits. We'll see what the state has to do with that, and we'll have a response maybe May 10th. Is that sufficient? It's tight.
Well, that gives us 3 days to respond.
3 days. Yeah, that's right. Well, May 10th is I don't know when I'm going to read all this stuff too, because it's 14th. So if I don't have it by the 10th, then you're saying the 13th. I guess I can do that the night of the 13th. But also, the defense needs some space there too. And I don't think we want to push out that hearing. Can't do it by the 10th.
We have no idea what the defense plans on doing, and that only gives us 3 days to read, comprehend, and respond.
We'll deal with it. We'll deal with the 13th then.
Yeah, I mean, we can try, and if we need more time, we'll ask for more time.
It's just then on my end, you're looking at, I'm going to have really more, I'm going to need more time.
Your Honor, I don't expect reports. I expect to provide a witness list.
Okay.
I don't expect there to be reports.
Exhibits?
There may be exhibits. I think there will be at least 2 or 3. I know some will be things that they've already given us in discovery, so they shouldn't be new and surprising.
Okay. I mean, it's hard to have these tight, time frames because we also have other things to do. But Mr. Thompson?
Your Honor, it's completely unfair and unacceptable for us to get a list of witnesses with no idea what they're going to testify about. The names witnesses don't mean much of anything. And unfortunately,
Bill Thompson speaks now. Whew. He's pissed. Let's see. He's been like stewing and sitting there. Now he's ready to just go. Let me rewind to his beginning.
Okay.
Here we
And
go.
it's hard to have these tight, time frames because we also have other things to do. But Mr. Thompson?
Your Honor, it's completely unfair and unacceptable for us to get a list of witnesses with no idea what they're going to testify about. The names witnesses don't mean much of anything. And unfortunately, we're having a pattern in this case of last minute disclosures of witnesses and PowerPoints and all sorts of things that frustrates Your Honor's ability to assess what's going on because it's brand new to you, just like it's brand new to us. And I think that practice has to stop. We need substantive disclosures. If they're offering experts, the rules of discovery specify what you have to disclose regarding an expert, and that's not just the name. So what's being propounded by the defendant right now simply isn't within the rule. It's not appropriate. It's not fair to the court or to the state.
Okay, well, you don't have to have witnesses or exhibits, but you can have a response to say, well, this isn't fair, whatever you want to say. Otherwise, I just need to push out this hearing. I'm stuck.
I appreciate that, Judge. And
Basically, he just said, Bill, I'm stuck between a rock and a hard place, and you can either have your hearing or you can have your witnesses, and we're all in this situation. So deal with it. Be a grown up, put on your big boy pants, and let's go.
I guess we've said it before. It is more important to do it right than to do it quickly if we have to have a trade-off here. And that includes fairness to everybody involved, including the court. And I would prefer that this not be kicked off, but we're realizing that we're essentially 2 weeks or less away from these hearings, that apparently there are going to be a number of witnesses that nobody but the defendant knows who they're going to be and what they're going to try to say, and then we're expected to react in court. That's just simply not the way to operate an effective, efficient, fair process.
Well, let's explore this. How many witnesses are you expecting to have?
I'm expecting to have 2 on the 16th. At this point in time, I'm not expecting either one of them to write a report. I expect a couple of exhibits. Some will be things from the protected materials that the court allowed us to have already. There will probably be 1 or 2 other exhibits, maybe 2 that the state hasn't seen before. I can provide those. I intend to provide those. On the hearing on the 14th, I think there may be 2 witnesses on that hearing, 1 for sure, possibly a second. We haven't made that determination yet. If there is going to be any PowerPoint presentation, I will provide that to the state as well. If we have an expert who hasn't written a report, then we won't offer expert opinions. We'll offer opinions about why we know the discovery is available, why we know these items are available. The state knows full well what they have and what they're withholding from us. And it's not going to be about what they're going to show. We don't know what they're going to show, but we know they exist.
Damn.
Thank you.
Oh, I wish the hearing was open.
Well, I just want to have this hearing. I don't want to push it out. All I can say is do your best. I'll be fair about it. I'll give you more time to respond if you don't have that time. That's kind of where we are.
He doesn't want to change.
I just want to keep going. We got to get through all this discovery stuff so that we can get ready for the trial.
Well, and Judge, I do for the record need to clarify, the representations of the defense that we are intentionally withholding things that they're entitled to is just utter nonsense. We have strived. We are continuing every week to provide additional discovery. We have more discovery coming. We hope that much of what they felt they had to file a motion to compel on, instead of being patient and wait, because our discovery deadline is until September, that we'll have and be able to make that available between now and the hearings on the 14th. And there may very well be little, if anything, we have to fight about. Your Honor also noted there are some things that we simply do not have the power to access. And we have been trying consistently through cooperative efforts, as well as following the process with the federal government. They have been good partners, but they have their own rules to work with. The motions for the subpoenas to Steekum isn't the first TUI process, and the court is aware. We've been pursuing TUI process for all types of information for months. So the characterization that we are just consciously withholding information to frustrate the defense is utter nonsense. That is not true. We will provide everything we can that is providable under the rules. If we disagree on something, whether it exists or not, because I can tell you, many of the things that the defendant is trying to itemize, when we talk to our people, they say, that doesn't exist. So, I don't know what we're supposed to do at that point. We'll flesh it out at a hearing. And it may be that if they have experts who are going to say, well, such and such should exist, we might have to go find experts to say, well, in this case, it doesn't. Or
That's
no,
fine.
we'll see.
Well, that's exactly why I want to close it on the 14th, because we're going to have many arguments, apparently, about issue by issue by issue.
Yeah.
And, some of that should not be out of it.
Thank you, Your Honor.
Your Honor, I want to respond to that, and I could give you particular examples of things. And it's already been ordered to be given to us, the cast report, which was a draft that we were promised to have by March 31st. It's May 2nd. We don't have it. So for the prosecutor to stand up and say that I'm misrepresenting things, he's misrepresenting things, Your Honor.
Okay.
That's there.
You know what? Let's not go there. I mean, we can sort that out on the 14th.
Bill
I read
stands up.
everything. That's what the state was saying. I trust both of you. Okay, your integrity. So I don't want this pointing the.
He's like a parent, like, I love you both equally. Just get it together. I don't have a favorite. Just, and it's like trying to appease your kids, like, you're all my favorites. I love you all.
Fingers back and forth. I don't think it's very helpful. Doesn't really help me. It started at the last hearing, and I really want y'all to just tone it down a little bit. I mean, you can argue all you want, but when it starts to be personal, it's destructive. I mean, you're really, really good lawyers. So let's just focus on the
Bill
issues.
is?
That's
Your Honor, we're happy to. And when we get the cast report, we'll disclose it. If we do not have it, we are not withholding it. As simple as
I
that.
read that last night. Okay. I'm very prepared about what the issues are, okay, about the discovery. And that's why I want to be able to hear from both sides, okay, what is the problem with this? What do we need to go forward? And I'm going to try and help that. And I expect that both of you do the same.
Your Honor, I do have several other examples, but in light of what the court said, I won't provide them right at the moment. There are other issues.
I understand, and I understand your frustration. And it's a big deal. It's
It is a
really
big
important. I understand that too, and I acknowledge that. Sometimes, we just can't quite get what we want from other people who might have it that don't want to give it up. So,
I wonder if he's a Rolling Stones fan. Can't always get what you want. Sorry, that was a terrible singing voice.
that's one of my challenges on the 14th, and probably at the 16th too. Okay. Moving on. We've got all right. Some of these pending motions, there was no request or no response from the state, and I'm thinking that the motion to unseal parts of the IDP materials and motion to allow defense investigators to review the IDP materials, that we're going to be addressing that on the 16th. Is that?
Yes, sir.
That's the state's understanding, Ms. Taylor.
Yes, Your Honor. Well, we're happy to have a hearing on the 16th for both of those issues as well.
Great. I'm just trying to make sure that we're all on the same page, or at least the same date. But I wondered, okay, there's been a response on the alibi issue, and I don't know
There
if
has.
there is a request for a hearing, or if we just kind of let that lie for now. I don't know.
Oh, I think we read it.
What was your intention there, Mr. Thompson?
I think at some point we're going to need a hearing on it. We're busy enough for the next couple of weeks with these other hearings, so we haven't reached out specifically on that.
Okay.
If the court would like to select the date while we're together today for a hearing, we would be happy to.
Why don't we just
Stick
wait
that
until the 14th or 16th?
That's fine.
And there may be issues that come out of discovery that have some bearing on that issue. I don't know. You don't have to say anything there. It can read your mind sometimes, maybe not. All right. Okay, I'm going to sign those subpoena duces taken. The FBI. I believe that's related also to the 13th supplemental. Maybe I'm kind of losing track of it.
Your Honor, it does relate to one of our discovery requests, and I'm sure one of the numbered motions to compel. I'll note that when I speak about that on the 14th.
Okay, great. All right. Are there any other issues that we need to address today? Mr. Thompson, Ms. Jennings? Okay, Ms. Taylor?
Yes.
Okay, go ahead.
I want to say this in a way that doesn't come off finger pointing, because it's not. This is about how busy everybody is and how much time it takes to communicate to get hearings set, because there's a lot of people going a lot of directions. I would like the court to consider setting hearings twice a month, every other week, and the court can vacate those hearings if neither party notices something up for that hearing. There will be 14 days notice for either party if we have hearings on that basis. But that way we could notice up specific hearings and just have those set dates so that we're not bugging the prosecutor's office for a stipulation and bugging the clerk's office for a hearing and waiting to find that out. It would speed things up to have 2 times a month that we would know if I've got 14 days before this hearing, I can notice it up and it can be heard by the court. So that's our request, is that the court just preset a couple of hearings. These would not be like the lengthy motions to suppress that we'll probably need a couple of full days for. These would be these shorter motions that we could deal with in 1 to 2 hours.
All right. Thank you. I actually mentioned that at one of our hearings.
You did.
That's what we need to do. I think it would be more helpful to, I guess, have better communication. Okay. I don't know. Maybe you are having good communication with each side. It is hard, to get a hearing when the clerk has to contact you or contact Mr. Thompson, and this goes back and forth. I mean, it takes a lot of time for your assistant, the clerks. At the same time, I have a lot of other cases, and I have a lot of jury trials going from here really to the end of the year. So it's hard for me to say, okay, we're going to have it. I think I offered Thursday, like a Thursday afternoon. So I'm willing to do that. I might just set like once a month, maybe, and then if you need something more, just let us know. But I'll look at my calendar and set that up. I mean, I know you come down on Thursdays generally, so that's a good day for you, right?
Thursdays are fine, Tuesdays are fine, Fridays are fine. Wednesdays are rough, but whatever day works for the court, I'll make that work. I just think it's more important that we have a place to put these hearings so that everybody's not spending a lot of time asking each other what day's okay, what time's okay, that we just all know that this is the time. So whatever day works best with the court schedule, Your Honor, is just fine with me.
Thursday afternoon is probably
That'll work.
Monday is impossible. So what do you think about that, Ms. Jennings?
Yeah, that makes sense. I think Thursday afternoon be fine for the state.
Do you think twice a month? It's probably going to ramp up.
I suggested that just because then there's 14 days to the next hearing, so everybody would always have enough notice. This is why I suggested that, and to know that we have those to iron out issues that are going to arise. Again, these aren't for the motions to suppress; those will come later.
Maybe we'll start with twice a month to get through all this discovery. I hope we can all get past that soon. And move forward a little faster. Okay, anything else then?
No, thank you.
Okay, great. Well, thank you all, and have a good day. Beautiful day. Thank you.
All right, well, that was the end of that. That was an interesting one. Lots of fireworks and a little tension there between Bill and Ann. It's always kind of fun to watch, but of course it is entertaining, but it does pose problems when they're trying to work together and make this case move along. So hopefully they can get their act together, the state, and get their discovery to them, because they are owed that by their constitutional right. So they're only delaying it and hurting the case, hurting Brian's defense by delaying and not turning things over right away. It's not hurting the state at all. They're fine. They have all the information on their end, and they already probably know that Brian didn't do it, but they're still trying to make it fit somehow. So I think that's a big problem. And once these prosecutors start to be taken to task, like, hey, all the stuff that you're saying you have, hand it over, give it here, you're my client, you have video of my client committing the crime, but you haven't turned it over. Where is it? Once you start coming at the prosecutor saying, okay, I give it over, they start more and more delay tactics, as we've seen in other cases. And a lot of times they just dig deeper into their, they double down on their lies. And I'm not saying that that's what's happening here, but it has a lot of red flags that make it look like there's some cover-up prosecutorial misconduct maybe, or at least law enforcement misconduct. Definitely something fishy going on in Idaho. So what do you guys think? Let me know, please, in the comments below what you guys think of Idaho 4, what you think of Bryan Kohberger, what you think of all of this secrecy by the state. Are they trying to hide something? Tell me your thoughts below, and don't forget to like the video on your way out. I will see you in the next one. Take care, guys. Bye. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.